Be ready. Start. Defendant number 2 filed written statement on 13/6/2006 wherein he claimed that the plaintiff had not come to the court with clean hands. It was further pleaded that the alleged portion of common yard was exclusively in the use of defendants number 1 and 2. It was further pleaded that a wall is existing between the house of defendant number 1 and defendant number 2 and their houses were adjoining each other. It was further claimed by defendant number 2 that just to harass him and to grab the suit land, the plaintiff has moved the court without any cause of action. The existence of any common yard was denied by defendant number 2. It was further claimed that the plaintiff had no right to create nuisance and that defendant number 2 had every legal right to use the property in the manner he liked, being full owner of the suit property. Defendant number 2 denied the existence of ventilator and the water outlet as claimed by the plaintiff. Accordingly, he prayed for dismissal of the suit. The next contention of learned counsel for the appellant is that even if the lower appellate court was to set aside the judgment and decree of the trial court in her counterclaim, then also the lower appellate court has erred and issuing further direction to her to restore the original position of the common yard. It is submitted by learned counsel for the appellant that this was not even the claim of the appellant before the lower appellate court. Hence, the relief granted was even beyond the claim made by defendant number 2 before the lower appellate court and the trial court in the suit. Hence, it is submitted by him that the judgment and decree passed by the trial court be restored. Having heard the learned counsel for the parties and perusing the record with their able assistance, this court finds that the submission of learned counsel for the appellant requires partial acceptance and the rejection regarding the remaining aspects. So far as the argument of learned counsel for the appellant that counterclaim against a co-defendant is maintainable is concerned, the same is liable to be rejected. Where a defendant sets up a counterclaim and the plaintiff contends that the claim thereby raised ought not to be disposed of by way of counterclaim applied to the independent suit, the plaintiff may, at any time before issues are settled in relation to the counterclaim, apply to the court for an order that such counterclaim may be excluded, and the court may, on the hearing of such application, make such order as it thinks fit. Thank you.